Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is just an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning the case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Now, your felony cases are referred to as the more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can get if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. Now, if a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years, and a fine that does not exceed $10,000. Or if a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life without the possibility of parole, life in the state penitentiary without the possibility of parole, or death by lethal injection. Now, as I mentioned to you earlier, your case is a misdemeanor case, so you don't have to worry about those punishments. Now, misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, the Class C misdemeanor are cases that start in the Justice of the Peace Court or the municipal court. Now, they come to this court when a person is convicted in the JP court or the municipal court, and they appeal their case. In essence, they get a whole new trial. And so the case comes to this court. Now, the punishment range stays the same. Now, the punishment range for a Class C misdemeanor is the Class C misdemeanor, you can get only a fine. It's a fine only, and the fine cannot exceed $500. For example, an example of a Class C misdemeanor would be like somebody not wearing a seatbelt, speeding, not having an inspection sticker. Those are examples of Class C misdemeanors. Now, as I mentioned to you earlier, it cannot get any jail time. It's a fine only. However, if they fail to pay the fine, or if the fine was converted to community service and they failed to perform the community service, then the court can issue what is called a capias pro fine. That just simply means it's a warrant for your arrest to either pay the fine or sit the fine out in jail. And if you sit the fine out in jail, for every 1 day that you stay in jail, you will receive credit of $100 that will go toward your fine court costs. Okay. Now, the next highest misdemeanor is a Class B misdemeanor. Now, with the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days, which is 6 months in the county jail. Or you could be given a fine that does not exceed $2,000, or you could be given both such jail time and a fine. Now, the highest misdemeanor is a Class A misdemeanor. And the range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or you could be given a fine that does not exceed $4,000, or you could be given both such jail time and a fine. Now, you may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation, we commonly refer to it as deferred adjudicated probation. Now, with the unadjudicated probation, you do not have a conviction on your record. And if you successfully complete probation, the case will be dismissed and you may qualify for what is called a non-disclosure. Now, what a non-disclosure is, it just simply means that your record would be sealed to the general public. So for example, you get a non-disclosure, you apply for a job at Mobile Oil Company. They do a background check. They won't be able to see the case that you received deferred on if you have deferred adjudication because they're part of the general public. And the operative word is general public. There are certain agencies in the Texas Code of Criminal Procedure, like the police department, they can have access to it. But the general public, which is most of the public, cannot have access to your record if you have a non-disclosure. Now, the next type of probation is called adjudicated probation. We had unadjudicated probation. The next type is called adjudicated probation. We commonly refer to it as regular probation. Now, with the adjudicated probation, it does result in a conviction on your record. However, there is something that is called judicial clemency, whereby the court or judge can set your conviction aside. You will no longer have a conviction, and you will not have it on your record. Now, if you get a subsequent conviction, that is, if you get another conviction later on, then the case that you received judicial clemency on can be revived, resurrected, brought back up and used against you. And if you try to get a license with Child Protective Services, they can deny giving you a license, or if they have a license, they can revoke or suspend your license. Now, the paperwork, everyone that's here for arraignment, you should have a clipboard with paperwork on it. I'm going to go over that paperwork with you. Now, arraignment is an opportunity for us to tell you what your rights are, what your options are, and that document, the first document, not the little short page, but the first document is titled Judge's Explanation of Rights of Defendants Without Attorney. And that document, we're going to constantly refer back and forth to that document, but that document basically states that as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. Now, if you like an attorney and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date from the day to give you time to hire your attorney. Now, the next sentence, or the second sentence, states that if you want an attorney, but you cannot afford to have an attorney, then you may request that an attorney be appointed to represent you. But you must first fill out the financial questionnaire so that the proper person can determine whether or not you qualify for an attorney. Now, the financial questionnaire is a 3-page document that is also on the clipboard. Now, this is only for people who will be applying for a court-appointed attorney. If you're not applying for a court-appointed attorney, you don't have to worry about this document. But for those of you who will be applying for a court-appointed attorney, you would have to read and fill out the first page of this document. On the second page of this document, you would have to fill out the top portion that is titled Defendant's Oath, and the middle portion that is titled Unsworn Declaration by a Defendant. And then you'll stop. I'm going to give you time to fill out that paperwork. Next, we're going to refer back to the judge's explanation of rights to defendants without attorney. Now, the third one sentence paragraph is for individuals who will be representing themselves. If you're representing yourself, that means you are your lawyer, you are your own attorney. And just like an attorney will have an opportunity to talk to the district attorney or assistant district attorney, or we call them prosecutors, and we have two of them here in court, you will also have an opportunity to talk to them if you're representing yourself because you are acting as your own attorney. This one sentence paragraph states that you may not speak to the prosecutor unless you first sign a waiver of counsel. Now, the waiver of counsel is another document that is on that clipboard, and it is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. This document will be signed by those individuals who will be representing themselves. If you're not representing yourself, you don't have to worry about this document. But for those of you who will be representing yourself, you would have to read and sign this document. And this paragraph that's in block form, second to the last paragraph, for individuals who will be representing themselves, it states that be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. And the last one sentence paragraph states that if you're representing yourself, you may change your mind at any time and request that an attorney be appointed to represent you. So for example, let's say you're representing yourself and you would like to see if the prosecutor is going to offer you probation. Let's say you want to defer probation or unadjudicated probation. And talk to the prosecutor say, no, we're going to offer a fine or we're going to offer jail time. And you say, well, I don't want that. Well, then you can ask this, you can say, well, Judge, I changed my mind. I don't want to represent myself. I want an attorney to represent. Okay, so if you're representing yourself, at any time, you can change your mind and ask for an attorney to represent you. Okay, now at the bottom of this document, first document, you're going to see 5 lines to the left. Everybody here before is going to put your initials on one of these 5 lines. If you are hiring your own attorney, you want to hire your own attorney, you will place your initials on the first line to the left. You sign on the line that's titled defendant, you'll date it, and then you'll stop, and this is all the form that you'll have to send. If you've already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. You'll sign where it says defendant, date it, and then you'll stop. This is all the form that you'll have to sign. Now, if you are applying for a court-appointed attorney, then you'll place your initials on the third line to the left. Sign, dated today's date, February 24th, and then you will fill out this document that is titled Jefferson County Affidavit of Injury. You fill out the first page of this document, the top portion that says defendant's oath, and the middle portion that says unsworn declaration by defendant. Going back to this first document, there's an explanation. If you have already been appointed a court-appointed attorney, in this case, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. You'll sign, date, and this is the only form that you would have to sign, and you would stop. Now, if you like to represent yourself, that is, waive your right to an attorney, give up the right to have an attorney to represent you, then you'll place your initials on the fifth line to the left, and you're going to sign, date it, and then you'll fill out this form that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. Okay, do we have any questions? Okay. Okay, now, moving right along to, continuing with your rights. You have a right to have you could enter, let me back up. You could enter a plea in your case. Okay, you could enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or you could enter a plea of guilty. If you enter a plea of guilty, then you're telling the court that you committed the offense that you've been charged with. Or you could enter a plea of no contest. And no, if you enter a plea of no contest, you're telling the court that you will not be contesting or you would not be fighting the charges. Now, you have a right to have a trial by jury. And where those young people are sitting, we call it the jury box. Now, they have 12 seats, but in a misdemeanor court, you only have 6 jurors. So 6 jurors will be selected, unlike the felony court where you have 12 jurors, but in the misdemeanor court, you have 6 jurors. So 6 jurors will be selected, and they will listen to the evidence that's presented by the state, by the defense. They listen to the arguments of the state and the defense, and then they will go back into the jury room, deliberate, and they will decide to find you either not guilty or guilty. You also have a right to waive your right to have a jury trial or give up the right to have a jury trial. If you waive your right to have a jury trial, you still can have a trial. Somebody might ask, how are you going to have a trial without a jury trial? You can have what is called a bench trial. And it's a trial by judge where the judge will be the judge and the jury. The reason why they call it a bench trial is because the judge sits on the bench. So they call it a bench trial. Okay, so you have a right to have a bench trial. The judge will listen to the arguments of the state. The defense listen to the evidence presented by the state and the defense. And the judge will apply the facts to the law and decide whether or not to find you not guilty or guilty. Now, if you don't want a trial at all, and you want to enter a plea of guilty and no contest, then you can have an opportunity to see if you can work out a plea bargain with the state. Now, there are 2 types of plea bargain. One type of plea bargain is called an agreed plea bargain. That means you and the state has reached an agreement to settle your case. You wanted probation, the state offered probation, then it goes before the judge. The judge can do 1 or 2 things. The judge can either accept or reject the agreement. Now, if the judge rejects your agreement, then you can say, well, judge, since you're not accepting the agreement, I take my plea back. I'm not pleading guilty or no contest. You have a right to do that. We say that you have a right to withdraw your plea if the judge does not follow the plea bargain agreement. However, now if the judge does follow the plea bargain agreement and you decide, you know what? I think I've been wrongly convicted, or the court committed an error by convicting me. I like to appeal my case. And so you say you like to appeal your case, then you have to get permission from the judge that follows the plea bargain agreement. Now, if the judge gives you that permission, then your case is going to leave this court and it's going to go right upstairs to the 9th Court of Appeals, where there are 4 judges, 4 justices on the bench. And what they will do, they can either grant or deny your appeal. If they grant your appeal, they can simply find you not guilty. Case over. Or they can send the case back down to this court with orders, give you a whole new trial. Now, if they deny your appeal, guess what? You can appeal it to a higher court than them. You can appeal it to the highest criminal court in the state of Texas, located in Austin, Texas. It's called the Texas Court of Criminal Appeals. And you would have to file what is called a pro se, and PROSE, pro se petition for discretionary review. Pro se means you represent by yourself, you represent yourself. And so you're going to be petitioning them or asking them to review your case to see whether or not the 9th Court of Appeals should have granted your appeal, or whether or not this court committed an error by convicting you. And then they can do 1 or 2 things. They can grant or deny your petition. If they grant your petition, they can simply find you not guilty and case is over. Or they can send the case back to the 9th Court of Appeals with order, so they can send it back down here to the county court at law with orders. Or if they deny your pro se petition, then at that point, your conviction will stand. All right. Now, you also have a right, I said you had a right to have an agreed plea bargain. You also, there's something that's called unagreed. Unagreed means that you talk to the state wanted to offer you jail time, you wanted probation, and so you're not taking that, but you still want to enter a plea. And so you want to have an unagreed plea bargain, which means that you want the judge to decide what your punishment is going to be. We call that an unagreed plea bargain because you couldn't make an agreement with the state. And so the judge will decide what your punishment will be anywhere within the punishment range. Okay. Now, you have a right to have witnesses to come to court. And what witnesses do, they can testify for you or against you. If you represent yourself, you can ask them questions. If you have a lawyer representing you, your lawyer can ask them questions. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses. What that means is you have a right not to call witnesses. If you do not call witnesses, does not mean that the state will not call witnesses, because they will be calling witnesses in the case. Now, you also have something that's called a Fifth Amendment right against self-incrimination. And it's as simple. The Fifth Amendment of the United States Constitution gives all of us the right to remain silent. Now, I know a lot of times we watch television shows like Law and Order, or we might see the television lawyer go up to the witness stand and ask the witness a question. The witness say, "I take the fifth." And so what the witness is saying is, I'm exercising my Fifth Amendment right against self-incrimination. I'm not saying that. And you have a right to do that. And if you think about it, it makes sense. Why it makes sense? Because the state of Texas has the burden of proof to prove that you are guilty of the charge. You don't have to prove yourself guilty. Okay? So you have a Fifth Amendment right to remain silent. Now you can waive or give up your Fifth Amendment right. That is, you can say, I'll take the witness stand. Okay, so you can waive or give it up. And if you waive or give it up, then you'll take the witness stand and you can get cross-examined. The other right that you have is a right to have what is called discovery. And what discovery is, I guess they call it discovery because you have a right to discover or see what's in the state's file. In essence, whatever the state has against you, the evidence that they have against you, you have a right to see that evidence. They call it discovery. Now, you have a right to see witness statements, your statements, police reports, lab reports, videos. You have a right to see photos, listen to audio recordings. You have a right to see the instruments or any objects, documents, whatever they have as evidence that they're going to be using against you in your case. You have a right to see that. They call that discovery. Now, you can waive or give up your right, and that's you can say, well, I don't want to see it. Well, you have a right to waive or give it up. Okay. Now, everyone that's here for court today, charges have been filed on you, you've been arrested, you've been placed in the Jefferson County Jail, you're out of jail either on a cash bond, which means that you pay the full amount of the bond to get out of jail, you're out of jail on a surety bond, which means that you pay the bondsman a percentage of the bond to get out of jail, or you're out of jail on a PRR bond or a personal recognizance bond, which means that you do not have to pay any money to get out of jail, you're just released under your own personal recognizance with a promise to appear today. I say that to say this. Every day that you spent in jail, it can be used as credit towards your punishment. The operative word is every day. Okay. Let's say you were arrested 11:59 p.m. Well, you was arrested, but you was booked in the jail 11:59 p.m. last night. And you booked out of jail 2 minutes later at 12:01 a.m. this morning. You get credit for 2 days. You was in jail 2 minutes, but you get credit for 2 days because it's 2 different days. Okay? So every day that you spent in jail, it can be used as credit towards your punishment. So for example, let's say you spend 5 days in jail, you talk to the state is offering you 5 days in jail. You don't have to serve any more time in jail. Why? Because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you've already served. Now, if they offer 7 days in jail, you serve 5, that means you would have to only serve 2, because we subtract 5 from 7, it leaves 2. Now, every day that you spend in jail can also be used as credit toward your fine and court costs. As I mentioned to you earlier, every day that you spend in jail, you're credited $100 per day. So in our scenario, you spend 5 days in jail, that's $500 credit towards your fine and court costs. So if the state is offering you fine and court costs of $500, guess what? You don't have to pay it, because the 5 days you spent in jail has already paid it off. Therefore, you will be given what we say is tax in retirement. Now, if the state is offering fine and court costs of $700, that means you have to pay $200. Now, you'll be required to pay it on the day that the case is taken care of. If you cannot pay it, no problem, because we can put you on what is called a payment plan, where you can pay it off in small monthly installments. Now, let's say you do not have enough money to pay it off on a payment plan, no problem. Then we can convert it to what is called community service, where you will be performing community service at a nonprofit organization in Jefferson County. And every 1 hour of community service that you perform, you will be credited $12.50 that will go towards your fine and court costs. So in our scenario, you have $200. If you work 1 8-hour day, that's $100. So you work 2 8-hour days, that's $200, and then the fine and court cost is paid off. All right. Now, Jefferson County District Attorney's Office has a program for first-time offenders. If you've never been in trouble before with the law, then they have a program where they will dismiss your case, and you could get it wiped off your record. Okay, the program is called pretrial diversion. And what happens is you get into the program, they dismiss the case, you complete the program, you can get it expunged. That means erased, deleted, or wiped off from your record. And the only qualifications is this. It has to be your first time getting in trouble. It could be one or more cases. And sometimes people go on a spree. You know, it's the first time, but they might get 2 or 3 cases that first time. But that's your first time. And so they can, that's your first time. You have to have an attorney to assist with the application process. The attorney could be appointed. They'll have to be hired. And it cannot be an offense that's involving unlawfully carrying a weapon or resisting arrest. But any other offenses, you can get in. Now, if you're a veteran in any one of the branches of the United States military, the District Attorney's Office has another program that is called Veterans Court. And with the Veterans Court program, what they will do is for veterans only. What they will do is you get into the program, you complete the program, you dismiss the case, and you can get that either expunged or you get a non-disclosure. Okay? That is, it's wiped off your record. Now, this court, County Court at Law number 2, has a program that God led me to start within the first 100 days of taking office. The program is called the CSI program. CSI stands for Community Safety Initiative. It is a program that is designed to address the issue of what we call recidivism. Recidivism means people commit crimes over. And so how do we address it? Well, we address it through our CSI program. And with the CSI program, the reason why we have that program is because, there's a cycle. And the cycle normally starts where person does not have an education, they have an education, they can't get a job, they can't get a job, they get depressed, they turn to drugs and alcohol. Once they turn to drugs and alcohol, eventually they commit a crime, eventually they get caught, and they do time. Okay? So then to address that problem, we have our CSI program. And with the CSI program, we have partnerships with various agencies. And in fact, we have 2 agencies here. We have Family Services And we have Spindletop. They're gonna come to you in a little bit more, in a few minutes and tell you a little bit more about the program. But basically, Spindletop is our local mental health program in the Southeast Texas region. They have the expertise to deal with mental health issues. And so today, what they can do is they can do a private interview in our jury room at their facility by telephone, whichever is convenient for you. They can do an assessment. Assessment is to determine what your mental health issue is. And they can develop a treatment plan to address your mental health issue. Now, you do not have to be incompetent or insane to participate in the program. You could just merely suffer from depression, anxiety, or any other host of mental illnesses, and they have the expertise to address your mental health issue. They also have another drug and alcohol recovery program that is called ATAR. ATAR is the acronym ATAR that stands for Addiction Treatment and Recovery. We also have a partnership with our local drug and alcohol council that has a program that is called OZAR. OZAR is OSAR, and it stands for Outreach, Screening, Assessment, Referral. Both of those programs are drug and alcohol recovery programs. And what they will do a screening, an assessment to determine what your issue is with drugs and or alcohol. And they can develop a treatment plan for either outpatient, inpatient treatment. If you are unemployed, or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center. We have a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in any one of those areas, they will help you to get a job in the area that you're trained in. Now, if you have not graduated from high school, if you do not have your GED, they have a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I mentioned to you are free. Does not cost you anything but time. And I like to say in this court, we do not just give time, we take our time. That is, we do not just arrest the problem, we address the problem. We believe that if we address the problem, we can produce productive people. And if we produce productive people would not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to county court at Law Number 2 of Jefferson County, Texas, we do not just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes in the community. And so if you're interested in any one of these programs, just let us know and we can get you started on the road to living your best life. So at this time, we have our mental health deputy, Deputy Powell, and we have Tanya from Spindletop. They're going to come to you at this time to tell you a little bit more about the program that they have to offer.
Joe.
You're welcome.
All right. I am Terrence. We have 5 on the side. About 10 years ago, we started this program with Spindletop. It's worked out pretty good. They put it into a student mental health crisis prevention program, and then we Spindletop. Found off and we drive together, get used together, and just do everything together all day. Like that.
Okay.
Said Lane, we talk, we have each other's matter. Yes. I don't anymore. Want to drop on that. So, anyhow, we work out pretty good. We respond to product communities. The whole aspect. I'm not reverse hospitality. We're trying to say today is going to be our job is to keep out of jail. Got a hospital. So on that 4 that we and funds and go that one. But you know, like,
Good morning, y'all. Executive Holmes said, and Judge Holmes will spend the top. I'm gonna give you a little sheet that we gave out to you guys. You guys can fill that out if you would like to speak to us today, one-on-one. You can also make the option of text or email, which that'll come directly to myself or my partner. We have something for you. We have mental health. Also, we have financial assistance. We have transportation, which every call or when call other deputies will be doing the transporting. Say you need to go to the doctor, or you need to have a visit with one of the counselors or psychiatrists. We are able for you guys to pick up. With our subsidies, we do have classes on site, which we can help you sign up for those classes once we speak with you. Everything that we talk about, you guys, is totally confidential. No one but myself and the deputies will have that information. Any questions? Nope. I'll give you guys a few moments. Normally, Judge Holmes will go ahead and give us some information as your procedures are gonna move forward. And your ability goes up to the funeral.
One question, and we decided to represent ourselves, can we just talk to the DA today
Yeah,
and move forward? Okay.
Thank you, guys.
okay. Okay, ladies and gentlemen, at this time, we have Johnny Stewart. He's from Family Services and individuals who have cases involving, family violence. He's gonna talk to you about, the program in family service.
Thank you, Judge. Good morning. I'm Johnny Stewart. I'm with Family Services of Southeast Texas. And we have our program, what we call the BIP program. It's the Veterans Intervention and Prevention Program. And it's for first-time offenders. You know, if this is your first family violence or domestic violence charge. We have a program available for men and women. And it's 18 weeks, 2-hour classes, one class per week. And we help you, we give you tools and information how to change behaviors. Because just like, you know, the judge said, we don't just arrest the problem, we arrest the problem. And if, you know, you think that program is going to really help not only you, but it's gonna help your family also. And it's gonna help you in other situations also. It's a very good program, been going on for years and years and years, and very successful. And I'm very proud of the young men and women who are actually complete the program, because we have seen changes. One of the things is that we would like to provide those who do not have access to come actually in person. We have Zoom classes that we do online, but we also have in-person classes also. So if you get an opportunity to take advantage of the program, have to remove from your record, I would recommend you do so. I'm gonna leave some flyers over here for anybody who's interested in the program. Thank you very much for your attention.
Okay.
Thank you, Judge. Appreciate
Okay,
it.
thank you, Mr. Stewart. Okay, now, ladies and gentlemen, as I mentioned to you earlier, I'll give you time to fill out the paperwork. Once you fill out the paperwork, we're gonna pick the paperwork up, we're gonna put you into one of 3 categories. One category is that you wanna hire your attorney, and you wanna hire your attorney, your case will be reset today to give you time to hire your attorney. If you wanna if you're in the category that states that you would like to apply for court-appointed attorney, then your attorney, if you qualify, your attorney will be appointed today. And if you would like to represent yourself, then you'll have an opportunity to talk to the prosecutors today. And if you agree with the offer that they're making, then your case will be taken care of today. All right, it's gonna take us a few minutes to pick up this paperwork. If you need to use the restroom, there are 2 restrooms right out in the hallway. We have the men's restroom in front of County Court number 3, which is right next door, and on the opposite side of the hall, there's the women's restroom in front of the 172nd District Court. Now, you'll be allowed to use the restroom. Do not leave the courthouse. If you leave the courthouse and your name is called, a warrant is gonna be, your bond is gonna be forfeited, a warrant is gonna be issued for your arrest. You're gonna be arrested, placed back in the Jefferson County Jail, You're gonna bind out, and guess what? We're gonna have to go through this all over again. And so to prevent that from happening, we're gonna try to get you in and out as quickly as possible. If you need help with your paperwork, we have our core personnel who's here, including myself, who will be happy to help you, finish filling out the paperwork. If you need any help, just raise your hand, and then we'll ask you to come up and we'll help you with the paperwork, or we'll come out to you and help you with the paperwork. So at this time, the court will be in recess to give you time to finish filling out the paperwork, and then for us to pick it up. Okay? Yes.
Before we get the paperwork out, can you tell us if you have a class A, B, or C?
What kind of case is it? Well, okay, yes, do this for the judicial academy.
Yeah, we have to go to the court, but,
Okay, that's right. Let's do this here. Jefferson County Court of Law number 2 is back in session with the arraignment docket. First case is cause number 25 CCCR 3032. Case is style of State of Texas versus Cameron F. Smith.
Yeah.
Mr. Smith, your full name is Cameron F. Smith. Mr. Smith, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Smith, you may put your hand down. How you doing, Mr. Smith?
Good.
That's good. Now, Mr. Smith, I have before me on this sheet of paper that's titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to have your case reset to hire your own attorney?
Yes, sir.
Now, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Smith, your case is going to be reset to give you an opportunity to hire an attorney. Our court coordinator is going to reset your case. Once she resets your case, you're free to go. And you have a blessed,
Yes, sir.
you have a seat in that first chair on the wall. Yeah, you don't have to be up here for this, please. Martin Cruz. Mr. Cruz, your full name is Martin A. Cruz. Mr. Cruz, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Cruz, you may put your hand down. How are you doing, Mr. Cruz?
All right.
That's good. Now, Mr. Cruz, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, Your Honor.
And are these your initials on the line that state you'd like to apply for the appointed attorney? Mr. Cruz, before you sign and initial this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Cruz, your case is going to be reset to give you time to hire your own attorney. Our court coordinator is going to reset your case. Once she resets your case, you'll be free to go. You have a blessed day. Please have a seat in the second chair on the wall. Next case is cause number 25 CCCR 3034. Case is style of State of Texas versus Jacob Johnson. Mr. Johnson, would you please come forward? Mr. Johnson, your full name is Jacob Johnson. Mr. Johnson, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing, Mr. Johnson?
Good, Attorney.
I'm doing fine, thanks for asking. Mr. Johnson, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that states you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Judge's Explanation, well, that's titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there is a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
Now, Mr. Johnson, before you sign and initial these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Mr. Johnson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed, since you in this case, is Attorney Don Boudreaux. Attorney Boudreaux will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall. Monique Antoinette Guillory. Ms. Guillory, your full name is Monique Antoinette Guillory.
Yes.
Ms. Guillory, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Guillory, you may put your hand down. How are you doing, Ms. Guillory? That's good. Now, Ms. Guillory, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
Is this your signature on the line that's titled Defendant? Or these your initials on the line that state you like to apply for court-appointed attorney? Also have a document that's titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Ms. Guillory, before you signed and initialed these documents, did you read the document? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Guillory, I read your answers. Based on your answers, you meet the eligibility requirements with the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Tom Burbank. Attorney Burbank will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in the second chair on the wall. Darlene G. Hargraves. Ms. Hargraves, your full name is Darlene G. Hargraves. Ms. Hargraves, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Hargraves, you may put your hand down. How are you doing, Ms. Hargraves? That's good. And Ms. Hargraves, I have two documents before me. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? And on page 2 of this same document, there is a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Ms. Hargraves, before you sign and initial all of these documents that I'm showing you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes.
And is everything in this document, in these documents, true and correct to the best of your knowledge?
Yes.
Ms. Hargraves, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in your case is Attorney Christy Carlton. Attorney Christy Carlton will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. You are. Star Hampton. Ms. Hampton, your full name is Star Dean Hampton. Ms. Hampton, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Hampton, you may put your hand down. How are you doing, Ms. Hampton? You doing okay? That's good. Now, Ms. Hampton, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant? On the next line, there are a set of initials on the line that state, I would like to apply for a court-appointed attorney. Are these your initials? And on the next document that's titled Jefferson County Affidavit of Indigence, do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled defendant signature. Is this your signature? Ms. Hampton, before you signed and initial these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay, Ms. Hampton, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that's appointed to represent you is Attorney Jennifer DeLodge. Attorney DeLodge will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Okay. Okay, the person that's on Zoom, take your mic off of mute.
Yes, sir.
Okay. You need to take your hat off and your hoodie, because you're in court. Okay, now, sir,
Yes, sir.
okay, what's your name?
Vidrick Blackwell.
Oh, that case was reset.
Yes, sir. That's what
They,
I'm calling
they
about
told,
because
they,
I wasn't.
I know, but they told whoever came, you think it was your wife? Someone came into court, they told her to stay in contact with the bondsman because you will be given another court date.
Yes, sir. And I called the bondsman. And
Well, they don't have the court date yet. So you have to keep calling them until they get a court date.
Yes, sir. And when I called him today, he because I asked him how come I wasn't informed about the court date today. He said that the lady that used to work there doesn't work there anymore, so he didn't know anything about it. So just keep calling them.
You're right. You'll be given another court date. Your bond
Okay, because
information was not in the computer.
yes, sir. Because when I contacted the bondsman today, he told me that I would have to keep calling Jefferson County for a court date and not him.
Well,
It was Nikki Bell Bonds in Jasper.
they're supposed to give you your court date, but
Yes,
you can do both, but they're supposed to give you a court date. Okay.
yes, sir. Yes,
All
sir.
right. You're free to go. You have a blessed day.
Yes, sir. Thank you, sir. You too.
Okay.
I'll hang it up.
Ayana James. Okay, this is cause number 25 CCCR 3020. Case is style of state of Texas versus Tiana Elise James. James, is that your full name? Okay, Ms. James, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. James, you may put your hand down. How are you doing, Ms. James? I'm doing fine. Thanks for asking. Now, Ms. James, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
Is this your signature on the line that's titled defendant? And are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
Now, on page 2 of this document, there's a signature above the line that is titled defendant's signature. Is this your signature?
Yes, sir.
Now, Ms. James, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Understand what you read? You did? Okay, well, just have a seat. Actually, I explained it to you, but have a seat. We'll call you back up.
It's just the difference with, what I put my initial to and, representing myself, like, what's the difference? What's the difference? I know the difference, but
Which,
if I do it, if I.
Okay,
do
you
a
say you wanted
court
to-
attorney, I'm gonna have to wait. If I represent myself, I'm still have to wait, or, cause I don't think my case that serious.
okay, well, you have the option, as I mentioned to you earlier, You can waive your right to an attorney and represent yourself, and if you do that, you'll have an opportunity to talk to the prosecutor who's in court to see if you can work out your case. But I also mentioned that there are dangers and disadvantages of self-representation. Waiving your right to an attorney representing yourself may result in the worst outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. So, what do you want to do?
What I saw for.
You want to see if, okay, qualify for a court-appointed attorney? Okay, now, Ms. James, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, now, Ms. James, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you, and you will be given information to contact him. But before I give you that information, the court bailiff is going to give you some bond conditions. I'm going to go over these bond conditions with you. And it states standard bond conditions in County Court of Law number 2. Do you see that title?
Yes, sir.
Go ahead, and it states, following return of a criminal information in County Court of Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state of the United States. Do you understand that condition? Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test of drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes.
And condition number 3, defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Condition number 4 does not apply. However, condition number 5 on page 2 does apply. And condition number 5 states, defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, if you violate any one of these conditions, your bond will be revoked, you'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes.
Okay, Ms. James, you're gonna have a seat in that third chair on the wall and wait for your name to be called. Once your name is called, you go to the window. Once you're finished, you're free to go and you have a blessed day. Can Derek Simeon? Mr. Simeon, your full name is Kenderick Simeon?
Yes, sir.
Simeon, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Simeon, you may put your hand down. How are you doing, Mr. Simeon? You doing good? That's good. Now, Mr. Simeon, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
Also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there is a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. Simeon, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Simeon, I read your answers. Based on your answers, you meet the eligibility requirements for the court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Giles Cole. Attorney Cole will be given permission to contact you, and you will be given permission to contact him. But before our coordinator give you that information, the bailiff is gonna hand you a document that is titled Standard Bond Conditions in County Court Law Number 2, and I'm going to go over this document with you. And do you see the title, Standard Bond Conditions in County Court Law Number 2?
Yes, sir.
Okay, and it states as follows. Following return of the criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number one, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number two, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, Your Honor.
Condition number three states defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, Your Honor.
And condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, Your Honor.
Now, Mr. Simeon, if you violate any one of these conditions, your bond will be revoked. Warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that?
Yes, Your Honor.
Okay. Now, Mr. Simeon, you're gonna have a seat in that first chair. Wait for your name to be called. Once your name is called, you'll go to the window, and then once you finish at the window, you'll be free to go, and you have a blessed day. Court is back in session. Clause number 25 CCCR 2874, case of Style State of Texas versus Mike Burrell Phillips. Mr. Phillips, is that your full name? Mr. Phillips, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Phillips, you may put your hand down. How are you doing, Mr. Phillips?
Oh,
Doing okay?
sure.
Now, Mr. Phillips, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Sure.
Is this your signature on the line that's titled defendant? Or these your initials on the line that state you like to apply for court appointed attorney? I also have another document that is titled Jefferson County Affidavit of Energy. You recognize this document? And on page 2 of this same document, there is a signature above the line that is titled defendant signature. Is this your signature?
Sure.
Now, Mr. Phillips, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Phillips, I've read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you in your case is Attorney Mark Faggett. Attorney Faggett will be given information to contact you, and you will be given information to contact him. The court coordinator will give you that information. Once she gives you that information, you'll be free to go. You have a blessed day. Please have a seat in that third chair on the wall. We need Jennifer.
I'm sorry.
Destiny Lackey. You have her paperwork?
Oh,
I see Porterless.
It's a dismissal, Judge.
I know.
everybody, all conditions, right?
Yeah, where's her paperwork she filled out? Okay, thanks.
Yes, sir.
Okay, this is cause number 25 CCCR 2446. Case is styled State of Texas versus Destiny Lackey. Ms. Lackey, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Lackey, you may put your hand down. Ms. Lackey, I have before me two documents. First document is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document?
Yes,
Is this your signature on the line that's titled Defendant?
yes,
Are these your initials on the line that state you like to waive your right to an attorney to represent yourself? I also have another document that is titled Waiver of Counsel, waiver of rights to defendants without attorney in a plea of guilty or proceeding to trial. Do you recognize this document?
yes,
Now, before you signed and initialed these two documents, did you read the documents? Did you understand what you read?
yes, sir,
And is everything in these documents true and correct to the best of your knowledge?
yes, sir,
Okay. Now, state, I have before me a dismissal. In this case, is that correct?
That is correct, Your Honor.
Okay, Ms. Lackey, the state is dismissing your case. I'm signing the dismissal. You can get a copy of this dismissal from our court coordinator in a few minutes. Just have a seat in that first chair, in that third chair. Wait for your name to be called. Once your name is called, you go to the one, then once you finish at the one, then you'll be free to go and you have a blessed day.
same to you, thank you.
Okay, thank you. Angel Garcia.
Good, how are you?
Muy bien, gracias.
Yeah.
Okay. This is cause number M 329-132. Case is style, the state of Texas versus Angel Eduardo Ladino Garcia. Mr. Garcia, Ladino Garcia speaks Spanish. We have our Spanish interpreter, Ms. Jennifer Raji. Ms. Raji, would you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Judge.
You may put your hand down. How are you doing, Mr. Raji?
Good, Judge. Thank you for asking yourself.
I'm doing fine, thanks for asking as well. And Mr. Raji, ask Mr. Ladino Garcia if his full name is Angel Eduardo Ladino Garcia.
Angel
Eduardo
Eduardo
Ladino
Ladino
Garcia.
Yes.
Okay. And ask Mr. Ladino Garcia to raise his right hand. Mr. Ladino Garcia, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. Okay. ¿Cómo está?
Bien.
Good. Now, Mr. Garcia, I have before me document that is titled Judge's Explanation. Ask him if he recognizes this document.
Yes.
Is this your signature on the line that's titled Defendant?
Ese es su firma ahí. Yes.
Or are these your initials on the line that state you like to have your case set to hire your own attorney?
Sí, eso es lo que quieres tiempo para agarrar un abogado. Yes.
Yeah. Before you sign this document, did Ms. Araji go over this document with you in Spanish?
Yes, Judge.
And did you understand everything that she went over?
Y usted entendió todo. Yes, Judge.
Okay. Now your case is going to be reset to give you time to hire your attorney. But have a seat in that third chair and wait for your name to be called and to get your case reset. Once your case is reset, you're free to go. Give a mistake.
Hasta que te llame el nombre de la señora y luego te vamos a dar la nueva cita, la puedes ir y que tengas un. Thank you.
Okay, thank you.
Yeah, it's on the screen. Yes.
Uh,
I have to tell him this.
Jose. That Jose's the lamb. Goaz.
Tazan.
Dazam,
Yeah, all the letters known.
Jose Dazam? Okay. Ask me if his full name is Jose Dazam.
Su nombre completo sobre eso. Zalam.
Salam. Okay. Now, Mr. Salam speaks Spanish and asks, Mr. Salam to raise his right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Acepto sería verdad, todo verdad, lo que Dios.
You may
Yes.
put your hand down.
Pues bajar.
Okay. ¿Cómo está?
Bien.
Bien? That's good. Now, Mr. Zalam, I have before me a document that is titled Judge's Explanation. You recognize this document?
¿Ese documento? ¿Tienes que decir?
Recognize the document?
Yes.
Is this your signature on the line that's titled Defendant?
¿Ese es su firma ahí? Sí. Yes.
Are these your initials on the line that state you'd like to hire your own attorney?
¿Y esas sus iniciales diciendo que quieres agarrar un abogado? Sí. Yes, Judge.
Before you sign this and initial this document, can Ms. Araji go over this document with you in Spanish?
Antes de firmar ese documento, ¿sí te explico todo en español? Sí. Yes.
And did you understand everything that she went over?
Y antes de firmar todo, sí te entendí lo que te explico de ese documento. Sí. Yes, Judge.
Okay, I read your answers. Your case is gonna be reset to give you time to hire your attorney. Our court coordinator is gonna give you your reset. Once you get your reset, you're free to go and you have a blessed day.
Dice que le van a dar tiempo para agarrar un abogado, le van a dar porque lo puedes sentar ahí en la silla, esperar hasta que te da. Y cuando se da su universidad, ya te puedes ir y que tengas un día.
Okay? Please have a seat in that third chair on the wall. Okay, thank you, Mr. Raji. You have a blessed day. Danielle Morales?
Sí, ella la van a dar parte de
This was Miss Mackey's.
porque aplicó de él, se le va a decir de nosotros, de seguro no está pidiendo. Y cuando te van a dar una hoja, poner la fecha ahí, ¿ok? En la misma fecha, como usted regresa a este tribunal, a las 9, se van a dar, ¿ok? All right, we're good to go. Thank you.
Thank you. Okay. Jefferson County Court of Law back in session. Court is in session to call for 2-5 CCCR 2796. Case is styled the state of Texas versus Danielle F. Perales. Ms. Perales, is that your full name?
Danielle Fanning Perez.
Okay. Ms. Perales, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Ms. Perales, you may put your hand down. How are you doing?
Okay.
I'm doing fine, thanks for asking. Ms. Perales, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney.
Mhm.
Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant? Or these your initials on the line that state you'd like to apply for court-appointed attorney?
No.
I mean, that you would like to represent yourself.
Yes.
Waive your right to an attorney to represent yourself. Okay. I also have a document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Recognize this document. And is this your signature on the line that's titled Defendant? And Ms. Perales, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Danielle F. Corrales, on or about September 23rd of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft of property that had a value greater than or equal to $100 but less than $750. Ms. Perez, do you understand what you have been charged with? And to this charge, how do you plead? Guilty, not guilty, no contest?
Guilty.
Let's see. And are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you are guilty? Ms. Perez, I also have before me a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes.
Okay, on page 2 of the same document, there are 2 sets of initials. First set of initials is on a line next to a box that's checked guilty. Would you place your initials on this document? Second set of initials are on a line next to a statement that reads, I do not request discovery. I waive my right to discover in this case and choose to enter a plea of guilty, no contest. Did you place your initials in the second location? On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature? And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Ms. Perales, before you signed
Yep.
and initialed all of the documents that I'm showing you,
Mhm.
did you read the documents?
Yeah.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Perales, are you a citizen of the United States?
Yes, sir.
The state will offer State's Exhibit Number 1, Judge.
Now, Ms. Perales, the state is offering State's Exhibit Number 1 into evidence. State's Exhibit Number 1 is the first document that I showed you. It's the same document that have your initials in the 2 locations on the second page and your signature on the first page. Is it all right for the state to use this document as evidence in your case? Okay, now, no objection, State's Exhibit Number 1 is admitted. Now, Ms. Perez, before we go any further, I failed to mention that you have a right to have a record. That is, you have a right to have a court reporter dictating everything that's being said. You also have a right to waive or give up your right to have a record in this case. Do you waive or give up your right to have a record?
Yeah.
Okay. Now, Ms. Perales, is there any evidence that you're currently mentally incompetent to stand trial? No? Okay, Ms. Perales, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is that agreement?
The censure term is as follows. It will be 3 days in the Jefferson County Jail. Time served, time actually served, and all court costs should be taxed every retired.
Okay, Ms. Perales, the state is offering that you serve 3 days in Jefferson County Jail, but you will not have to serve any more time in the Jefferson County Jail because you've already served 3 days in the Jefferson County Jail. Therefore, you could be given credit for the 3 days that you've already served. The court costs in this case will be taxed and retired. That simply means that the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Ms. Perales, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? Do you accept the state's offer? Ms. Perales, I'll follow the plea bargain agreement that you have entered into with the state. Now, Ms. Perales, you're going to stand at the end of that table, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go, and you have a blessed day.
Have anything you.
You're welcome.
I'll let you know, jingle jingle out, they're there.
Okay, this is stated, court is back in session, the cause number 25 CCCR 2855, cause number 26 CCCR 0181, case is titled State of Texas versus Chrislyn Rashawn Bolton. Chrislyn Bolton was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Chrislyn Bolton at the courthouse door. Chrislyn Bolton did not answer. Chrislyn Bolton has not appeared in court since the court has been in session. The time now is 11:56 a.m. on today's date of February 24th, 2026. Ms. Bailiff, would you please call the name of Chrislyn Bolton at the courthouse door?
Bolton, Chrislyn Bolton. No response.
Okay, Chrislyn Bolton's name was just called at the courthouse door. Chrislyn Bolton did not answer. A reasonable time has passed to give Ms. Bolton an opportunity to appear in court. She has not appeared in court. State, do you have a motion?
State, move for bond forfeiture, and that's a warrant issue, Your Honor.
Okay. The motions will be granted in each case. Chrislyn Bolton's bond will be forfeited and warrant should be expired. Arrest and cause numbers 25 CCCR 2855 and cause number 26 CCCR 0181. Next case is cause number 25 CCCR 2720. Case is styled the state of Texas versus Kevin.
That's not a good one, Jim.
It's not? Okay, we go to,
They do have a JP.
okay. Next case is Jacoby Hope. Okay,
Yes, I want to know, no bond on the image.
okay.
It's all the file.
Okay, Ruby Randall, no bond info in that one either. That's on page 7. It says no bond info. And that will conclude the calling of the court's arraignment docket in county court at law number 2, Jefferson County, Texas. You have Terrence L. Holmes presiding. Court will be in recess until 1 o'clock. We could start back with our trial.
Oh, what?
Yeah, pre-trial hearing. Trial will begin at 2 p.m.
Okay,
So the court will be in recess actually to 2 p.m.